Probate is the court-driven process to recognize that someone has died and that they owned property, and to appoint a representative of their estate. I've done thousands of probates. It's a public proceeding. It causes delay and costs money. Most people who hear that decide they'd rather simply avoid probate. Why go to court and expose your family to opportunists and encourage fights if you don't have to? This is where most probate avoidance plans just fall apart, especially the DIY ones. The target is not simply to avoid probate, but to maximize the benefit to your chosen people, your beneficiaries. Let me repeat that. Once you understand that a good estate plan is not just a game to avoid probate, but really finding a way to maximize the benefit to your loved ones, then you can make a good estate plan. Let me give you a few real-life examples of how this goes wrong. Tom put everything in joint ownership with his wife to keep things simple. When he died, she was deep into Alzheimer's, and the inheritance pushed her over the limit for Medicaid. The family had to spend down almost everything he had saved. Another example. Bill added his second wife to the beach house and his 401k. When he died, she remarried and changed every beneficiary to her new husband. Bill's kids got nothing. Another client left money outright to a son with spending problems. His creditors seized the entire inheritance in 3 days. And one mother who had 3 kids put only the one child on her bank account to help with the bills. That child legally inherited the entire account, and the resulting fight split the family for years. The real reason many families lose family wealth is because they start out with the wrong goal. They think the goal is to avoid probate. It's not. Put simply, the true goal of estate planning is to make sure that the right people get the right assets and the wrong people don't. And the tools people use to avoid probate often create much bigger problems. The most dangerous plans are the ones that look simple. Adding a child to a bank account, adding a child to your home deed, putting everything in joint tenancy, relying on beneficiary designations, or creating a trust that never funded. These steps seem efficient, fast, and cheap, but they create legal landmines waiting for your family. Those landmines go off at the worst possible time. None of those beneficiary designation style probate avoidance techniques allow for what we call the what ifs, right? These contingency plans, like, one of the contingencies is life. Let's start with joint ownership. Adding a child as a joint owner to avoid probate is one of the most common mistakes I see. It could trigger gift taxes, expose your home to your child's divorce or lawsuit risks, cause the loss of a step-up in basis, and can unintentionally disinherit your other children. Only the portion of the home you still own at your death receives a step-up in basis. The part you gave away during life does not. And here's the ironic part. You can still end up in probate because joint ownership doesn't solve everything. Joint ownership feels simple, but it creates problems you don't see until it's too late. Another trap is beneficiary designations, payable on death accounts, transfer on death deeds, retirement accounts with named beneficiaries. These seem like good probate avoidance tools, but they often cause chaos. They override the protective what-ifs built into your living trust or last will. They can create unequal distributions. They offer zero protection for beneficiaries with issues like addiction or disability or a spendthrift son or daughter. They trigger immediate distribution, which often triggers immediate conflict. And if a beneficiary dies before you, you're right back in probate. Estate planning can feel expensive, and online tools seem fast and convenient. But DIY estate planning often creates invalid wills, unenforceable trusts, missing signatures, missing witnesses, outdated documents, plans that contradict each other, and no estate planning lawyer pestering you to put your assets into your living trust. Most children who come to me after a parent dies with a DIY, that's do-it-yourself estate plan, they say the same thing. The plan didn't work the way mom thought it would. DIY is fine for assembling furniture. It is not fine for protecting your family's generational wealth. So what actually works to avoid probate safely? Here's the good news. You can fix all these problems by starting with the right goal. What's that goal? I'm repeating myself a little bit, but I think it's important to repeat. The goal is not to avoid probate, but to protect your family assets and prevent family conflict. So what actually works to avoid probate safely? 3 things. First, a fully funded revocable living trust. This avoids probate, but also includes all your what-if planning. A fully funded living trust allows you to control how and when assets are distributed and protects your family's privacy. Second, a coordinated asset titling plan. Your deed, bank accounts, retirement accounts, and life insurance must all be aligned with your trust. Third, regular estate plan reviews. Life changes, laws change, families change. A quick review every 3 years saves families more money than almost any other step. If you want to understand exactly where your plan stands today and what your parents' plan really does, if you're the adult child of a parent who's doing planning, download our free Life Counsel Probate Guide or schedule a conversation with a qualified, experienced estate planning and elder law attorney. If you need help finding one, listen to our podcast on how to choose an estate planning attorney. Your family deserves clarity, and your plan deserves to work when your family needs it most. Tell me in the comments what part of probate or estate planning confuses you the most, and maybe I'll cover it in a future episode, or maybe I'll just answer the comment.